Welcome once again to Lehto's Law. Here's Steve Lehto.
Tony sent me notes, so Steve, check out the story. And the story he sent me a link to was from techdirt.com, and Tim Cushing wrote it. It's a great article. But that article talks about a recent opinion from the Ninth Circuit Court of Appeals. And the subject of the opinion is something I did a video on back about 2-3 years ago. Episode 7.779, back when I numbered my videos. And that video has got 2.1 million views, which for my channel is amazing. But it had to do with the little girl who got handcuffed by police at school because of something she had drawn, allegedly. And it's interesting because there's all kinds of allegations going around. And so I read through these opinions and the orders and all this stuff. And it is a fascinating case. But the court has ruled that the lawsuit can proceed. And so the lawsuit is against the city and county of Honolulu, as well as the police department and the police officers. And what the girl is alleged to have done, the reason the police were called to the school, is they say that she had drawn a picture which depicted a girl holding a cartoon firearm pointed at someone else whose head was on the ground. And then there were words below it addressing two other students. And so somebody saw that, was alarmed by it, and they called the police. And the police came to the school, and while doing whatever they do, they handcuffed the little girl. And so that is, of course, what led to the lawsuit, and now they're fighting over that. And so there are a bunch of things that are of interest here, but I'm going to read the opinion first because the opinion is only 5 pages long. It's only 5 pages long. And that is that is short for an appellate court on something like this. So Honolulu Police Department officers who are named here as defendants appeal the district court's denial of their motion to dismiss the complaint, which is based on 42 U.S.C. 1983, and they are claiming that they have qualified immunity against these actions. So this court, of course, has jurisdiction over that. And they review the underlying action to see what they're going to do. And, of course, they reverse in part and affirm in part, and they remand it down for the case to proceed. They say we reverse the district court's denial of qualified immunity to the HPD officers as to plaintiff's false arrest claim. So there's two primary claims here. One was false arrest, and one was excessive force. And they say to determine whether qualified immunity applies in a given case, we must determine, one, whether a public official has violated a plaintiff's constitutionally protected right, and two, whether the particular right that the official has violated was clearly established at the time of the violation. So we've talked about this before. To show that something is clearly established, you have to go out and find case law that actually addresses specifically that kind of an action. And so it can't be general. It must be sufficiently clear that every reasonable official would have understood that what he is doing violates that right. When engaging in such a review, we accept as true all well-pleaded allegations and construe them in the light most favorable to the non-moving party. So plaintiffs claim, that of course is the little girl and her mother, that the HPD officers violated the child's clearly established right to be free of an arrest without probable cause. Plaintiffs rely on several cases that talk about this, but the court says that they must identify a case where an officer acting under similar circumstances was held to have violated the Fourth Amendment. And I've talked about this conundrum before. You've got to point to a case that found the way you want it to go. But if you need a case to go the way you want to go to have a case, then how would the first case ever get made? And so it seems like that it's either impossible or it takes such outrageous facts that someone's going to go, okay, that we don't need a precedent for that. But technically speaking, you do. And the court here says plaintiffs have failed to identify such a case. And they're talking about whether or not there was probable cause to arrest the little girl. And the court says, you're not going to win on that one. You can't win on that one. So they're going to affirm the dismissal of that. However, we affirm the district court's denial of qualified immunity as to plaintiff's excessive force claim. Whether the amount of force employed was excessive depends, of course, on the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. And that comes from a case from 1989. And of course, the court points out again that we must affirm the district court's denial if accepting all of the plaintiff's allegations as true, one, a constitutional right was violated, and two, is clearly established. Okay, so let's assume for a moment that handcuffing a little girl is excessive. Is there clearly established case law? Oh, it turns out there is. Because, and by the way, I did a video years ago, over 5 years ago, about police handcuffing children. And I said, this is one of those things that I just don't understand. And I actually got a lot of pushback from people telling me, like, I don't know what it's like in schools these days, and kids are violent, and what if they have weapons? There's no allegation that this kid had a weapon. So in one case involving the city of Sonora, we, the Ninth Circuit, held that the use of handcuffs on a calm, compliant, but non-responsive 11-year-old child was unreasonable. We also determined that the decision to leave the child in handcuffs for the duration of a half-hour commute to his uncle's business was clearly unreasonable. By the way, that same kid was handcuffed in the back of a car that had safety locks, so the kid couldn't get out. Following Sonora, no reasonable official could have believed that the level of force employed against a 10-year-old, as alleged in the complaint, was necessary, and there they placed her in adult handcuffs to transport her to the police station. Like the 11-year-old in Sonora, the child here was calm and compliant, was questioned in a secluded office surrounded by adults, and did not resist arrest or attempt to flee. Because at the time of her arrest, it was beyond dispute that handcuffing a small, calm child surrounded by numerous adults who complies with all of the officer's instructions and who is unlikely to flee was completely unnecessary and excessively intrusive. Officers are not entitled to qualified immunity on plaintiff's excessive force claim. That, unlike the situation in Sonora, the HPD officers may have had probable cause of the arrest in this case, does not mean that Sonora did not put them on notice that the level of force used in effecting the arrest was nevertheless excessive. And so they said there is qualified immunity on the probable cause argument, but the excessive force argument, no. The cops overstepped the bounds in that one, and they should have known that because there's case law in that circuit saying you don't handcuff a little kid who's compliant, non-threatening, cooperating with everything, and just sitting there. And I know some people are going to be very upset by this and say, oh, this is crazy. And the thing about it is, you have to understand, and I've told this story before. When I was a really little kid, I grew up in a town called Birmingham, Michigan. And Birmingham, Michigan was very, very calm, quiet little suburb of Detroit at the time. And not a lot happened out there. And so I don't think the police had a lot to do. And so I remember one day when I was probably in first or second grade, maybe, riding my bicycle. I can tell you exactly where I was. I can take you there right now and point to the sidewalk square we were standing on, if in fact that sidewalk is still there. And a police officer drove by and actually stopped and said to me and my friends to stop. He needed to talk to us. And he got out of his car and he walked over, and me and my friends were on bicycles. And he goes, why don't you guys have licenses on your bikes? And the city at that time had a voluntary program where you could pay a couple bucks and get a little sticker you put on your bike so that if your bike got stolen, theoretically, they could identify it. And I don't know which one of, whether it's me or my friends, but somebody said, are we required to have those? And the cops started lecturing us about it. Now, I understand that's nothing compared to what happened to this kid. But the point is, I remember it. I remember it more than 50 years later. I remember where I was coming from, where I was going to. I remember that interaction vividly. And sometimes things that happened to you as a child can be very, very impactful and memorable. And years later, they'll remind you. And so it's interesting. I've had interactions with the police since then, often at the side of the road. And I've also dealt with police officers as an attorney. I've cross-examined them and put them on the stand. I've taken depositions of them. So I've dealt with police officers. I've stood in the hallways and talked to them after a trial, during a trial. I've talked to them while I'm trying to negotiate a deal with my clients. I've dealt with police officers on countless occasions. I literally could not tell you how many police officers I've spoken to in a professional manner or again, like I said, in a civilian manner at the side of the road. However, the one that actually sparks the strongest memory for me is the one where I was riding my purple Stingray bike on a street called Bowers in Michigan, Birmingham, and a police officer stopped his car and told my friends and I to stop so he could come over and lecture us about putting licenses, which were not required by law, on our bicycles. Now, again, no lawsuit arose from that. I'm not saying it was the most traumatic thing that ever happened to me as a child, but my point simply is that if I remember that little interaction 50 plus years later, trust me on this, my friend, this little girl is going to remember this interaction for the rest of her life. Now, you're going to say, as a lot of people are, but Steve, that drawing she drew was bad, and there's nothing wrong with them calling the police. No, there wasn't. No, there wasn't. And there's something else that the courts pointed out, and Tim Cushing highlights in his article on techdirt.com, is that there are now questions as to how much of that drawing she drew, whether anybody added anything to it, and also its quote-unquote chain of custody. Because there are now questions that perhaps she drew part of it, someone else drew part of it, or added something to it, and then somehow the additional stuff was there when it was shown to the police. And that, of course, is a whole nother ballgame that I hadn't even thought about before. But I've also remembered stories when I was a little kid, people handing notes in class, right? Psst, give this note to them. And the teacher looks down and sees this person handing a note to that person. Give me that. Okay. And they yell at the person who's handing the note. But the note came from over here. And so there's an argument about that also. And so, yes, the drawing did show a picture of a girl holding a cartoon weapon pointed at someone else whose head was on the ground, which, by the way, I don't think that's how you get someone's head to fall off. I could be wrong. And then there were words below it addressing it to other students. But there's no allegation that she had given it to other students. And the question also, of course, is who addressed it? Who did that? Was that in her handwriting? Or did somebody add something to this drawing? And so these are all questions that are very, very good questions. We don't know the answers to them yet. But keep in mind, like a lot of these cases I talk about, where somebody files a lawsuit and the defense gets it thrown out, so it goes up on appeal, and a court says we're sending it back down again. Although we do say that the plaintiff won the appeal, at least this portion of it, they didn't win the case yet. They simply get to have their day in court. So they have the right now to have their day in court unless the case settles. A lot of these cases will settle when it is apparent it's going to go in front of a jury. And of course, one thing I have to tell you is that all of this happened a little while ago. Time is going by. As I mentioned, I did this in season 7 of this channel. I'm now on season 10. So the 10-year-old girl presumably is now closer to 13 or 14 years old. And who knows, maybe by the time this thing goes to trial, she'll be so much older, it'll be hard to imagine her as a little girl. But that's another story altogether. The point is that the lawsuit that they filed was on 2 theories, and that is 1, the arrest shouldn't have taken place, and 2, they used excessive force. The court said, probable cause argument goes out the window, but the excessive force does work because there is case law in the Ninth Circuit saying specifically you do not handcuff a compliant, nonviolent child who is cooperating with you. If there's no risk of flight, no risk of danger to others, you don't just handcuff them for the fun of it. And one of the things I mentioned in the video I did years ago about just handcuffing children in general is that quite often there are adults who think we can scare kids straight. So what we'll do is, to get this kid to behave, we'll call the cops. They're going to come in, read them the riot act, put them in handcuffs for a few minutes just to teach them a lesson. And then we'll let them out of the handcuffs and let's send them back to class. And that's not the role of the police, and it's not a proper use of handcuffs. So that's the problem I have with it. But again, like I said, I know there are people out there who disagree with that and say, no, Steve, for all you know, that could Kid could yank a weapon out of their pants, and next thing you know, yeah, all kinds of crazy things could happen, but they didn't. So, case is called Tamara Taylor versus Christine Neves, et cetera, et cetera. And Tony sent me the story. Tim Cushing did a great article on it in techdirt.com, and that's where I got the description of the drawing itself. And my original video on the topic, like I said, was 7.779. I'll put a link to that in the description below this video because some people want to see that. So there you go. It goes to trial now, or we'll settle. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Creative people don't see things for what they are. They see them for what they can be.